The role of the United States Supreme Court is not to create policies that you or I might like, but it has a deeper constitutional purpose.
There are disputes here and there about whether the court's doing the right thing. But when the court does something that's not supported by constitutional text or by some other legal provision, it's clear that they're outside the realm of what they've been asked to do.
The court recently started its new term, and on this episode, we give you a preview of some of the cases it'll consider, and we equip you to better defend the proper role of the Supreme Court. You're listening to Defending Ideas. Defending Ideas is a weekly podcast produced by Sutherland Institute. On this show, we are committed to renewing the principles of common sense conservatism, making you a better champion of sound ideas. Welcome to another episode of Defending Ideas. I'm your host, Nick Dunn, and joining us again on the show is Bill Duncan. He's the Constitutional Law and Religious Freedom Fellow here at Sutherland Institute. Bill, thanks so much for joining us once again on Defending Ideas.
Thanks for having me, Nick.
So we're talking about the Supreme Court because just in the month of October of this year, the court is starting their new term again, so they're considering a whole slew of new cases and issues. So we wanted to talk through that with you and get a preview. You wrote an article on the Insights blog here at Sutherland called Supreme Court 2023-24 Preview, 3 issues so far. We'll walk through some of that. I want to start off by asking you, this last year, June 2023, which is when most of these cases dropped, was a pretty robust month or so of public debate around these issues. Is June 2024 going to be just as contentious, maybe more so? Give us a sneak peek.
That's a great question. And 2022 is probably even more contentious, right? So that there is a pattern. Well, some of that is a natural function of the way that the court works, is they're almost always issuing the most carefully watched, maybe even we might say contentious issues at the end of the term, and the term ends in June. So to the degree that that any of these issues are going to be compelling for people, that's when we're likely to see them. Having said that, I think the issues are not as, they don't hit some of the kind of culture war kinds of topics that have been that the court's dealt with the last couple of years. But there are some really important things. And, one of the things that's always good to remember is that even if it's not carefully watched because we care a lot about it, doesn't mean that they're not doing some really important things that will have an influence on our culture, the way we run our government. So,
well, I want to get into some of the issues you wrote about in your Insights blog article. And first kind of start off with this question and ask you to go through one of the cases that's going to help address this. But there's a lot of discussion in our politics today about the size and scope of the federal government and the power of the federal government. I think sometimes it's easy for just members of the public to not be clear on what people mean when they say that. Does that mean that the president has too much power, Congress and what it's trying to do is too big? But I think in many instances, what folks are talking about when they talk about the size and scope of the federal government is federal agencies themselves.
Right.
So I want to start off and ask you that is, do federal agencies have too much power? Are they deferred to too often? And there's a case that kind of lines up with this.
Right. Well, so the answer to your question is, I think the answer is probably yes. One of the reasons I think that's of concern to people is we're not really quite sure how they're making the rules that they do. The other question, of course, is that with each administration, rules change. You kind of can expect when a new administration comes into power that you'll see some of the same changes go back and forth all the time. And that's a little bit unsettling. It's sort of like, well, we need some consistency. With Congress, of course, things change, but that's our assumption. We assume that when we're voting for people, we expect that they're going to make changes, and that's why we're voting for them or retaining the people we have because we don't want the changes. It's always a little more unclear why exactly the laws may change, how these affect us, how we even have a say in it, who these people are that we really haven't necessarily elected. We haven't in the sense that we elect a president who then appoints those agencies and sets their agenda. But so I think that's one reason why we have some concerns, and I think they're valid concerns. I think the agencies probably do more than they were intended to under our constitutional system.
So there's a court case, a case that the Supreme Court is taking up in this term that deals with this idea of Congress essentially delegating authority to federal agencies. This same issue, I believe, came up in our congressional series that Sutherland hosts each August, came up just this past year. Can you walk us through that case? What are the key questions involved, and maybe predict or suggest an outcome?
Sure. Well, the case, to understand the case, you want to think back to in 1984, and the Supreme Court had a decision involved the Chevron company, and so the question there was a challenge to regulation, and the court issued an opinion, kind of an evenly divided opinion, where it held. There's some dispute about exactly, what the court meant here, but what seems to be the case is that most lower courts have interpreted that 1984 decision to say that if Congress did not speak to a specific issue when they enacted a statute, they didn't necessarily speak to they didn't say you have to do this, you have to do that. The agencies have a lot of room to sort of fill in the blanks, and that the courts, if those rules are challenged, as they often are by people who are regulated, will have to defer to the administrative agency's decisions. And part of the thinking behind that is, hey, look, these agencies are probably staffed by people who are experts in scientific issues or whatever, so maybe it makes sense to defer to them. Of course, the challenge, let's get a step back. So this specific case, that there are actually a number of cases, 2 of them have been already accepted by the court for decision, and they involve a specific regulation about having a federal monitor. So this would be a person who's an observer who goes on fishing boats out in the ocean to make sure that the crews are obeying the federal regulations. And when you start to imagine that, I don't know if you've, it's kind of a funny picture in your mind. You have. I know this isn't sure the way it's done, but you think of all these, fishermen on a boat, and here's someone in a suit maybe sitting, and I don't know, I doubt they wear suits. But the point is, it is a little bit intrusive. And so the question is that what Congress had in mind? Well, Congress didn't say, it didn't really specify all of that. And so the agencies have filled in. And now they've maybe taken the next step is to say, well, and we want the fishermen to pay for this person's salary. So that creates, you can see from the perspective of the fishermen that they don't like that rule. And isn't that because Congress didn't specify how they would be paid? Correct.
You say that in your article.
Yeah.
So if the agencies essentially say, well, the fishermen themselves have to pay, how is that not just an illegal tax?
Well, that's right, and that's certainly the way that I think a lot of us would look at it, and certainly the way the fishermen look at it, and the way that they're arguing. So, but when you think about it, there's an underlying question of, maybe Congress, maybe they intended that. We really don't know, but they didn't specify it. And part of the challenge we have, again, is drawing the lines of accountability. It's one thing to say, if I had any idea that my congressman was going to vote that we sort of have to free up space on the, you can imagine the scenario, that they would be really frustrated, and they could go to their fellow citizens and say, we need to vote Congressman whatever out because they're doing this to us. In this case, the congressman can easily say, well, we didn't do anything like that. Who did? Well, it's an agency. Well, which agency? And it eventually goes down. I had to look up the agency and learn a little bit what they did just to write the article. So it's not even well known who's making a decision like that, where they got that authority. And then underscoring this question is what if the agency gets it wrong? Well, under the rule from the 1984 case, the Supreme Court theoretically has to defer to that decision. But that seems a little unsettling too. What if we want to have some checks and balances? We want the courts to be able to say, well, no, you're reading that a little too broadly. You're taking on authority that Congress really never intended to give to you.
Isn't it kind of antithetical to the idea of separation of powers and checks and balances to say, and this, I'm not a lawyer, so this is spoken from that lens.
You understand as much as anyone else does.
But to have this idea of the Chevron deference or the Chevron doctrine of, well, courts have to defer to agencies, doesn't that kind of just fly in the face of checks and balances in the first place?
Well, that's definitely the criticism, and there's kind of 2 ways of looking at this. One way of looking at it is to say, the Chevron case was has been overread by lower courts. In other words, they've assumed that they had less power than they really do. Maybe they could push back a little bit. But some of the critics and Justice Thomas, Justice Gorsuch specifically, have been very specific on this question. They've said, no, this is the duty of Congress the courts from the very beginning of our republic was to clarify what the law actually says. That's their role, is to defend the actual written law. And when if they somehow say, well, we would typically do that, but in this case we're not going to because it involves an administrative agency, that doesn't sit well with our thinking about separation of powers. So you're right. That really is the underlying issue in this case. Is there an effective separation of powers when the executive agencies are making the decision?
I want to read an excerpt from your Insights article that talks about this issue and then kind of get your reaction and see what needs to be the fix. And so here's a quote from your Insights piece on the Supreme Court preview. You write, if courts always defer to agencies, it creates a political incentive for elected lawmakers to draft intentionally vague laws, because doing so passes accountability for some of the most controversial and specific policy decisions to executive branch agency regulations. In short, judicial deference to executive agencies leads to these agencies exercising legislative power, creating laws in the absence of specific direction from Congress. Again, to a non-lawyer, that reads to me like we have a separation of powers problem that the court will presumably, hopefully, fix this term?
Yes, that's right. We typically think of separation of powers. You think of kind of the different branches of government as perhaps being at odds with each other. You're taking away my power, and obviously that does happen occasionally. But this is the problem with so much of administrative law, is that it has the effect of creating kind of perverse incentives. Well, gosh, maybe our intention is to close this space in a community that's going to be affected by that, or to designate a certain property, certain lands as public lands and limit the use, or you can see a whole range of things. But if you're a member of Congress and you think, well, I could also delegate that to someone else, then all the rage can be directed at them, and we don't have to deal with this. But of course, that's exactly wrong. The motive we have for transgressing the lines of separation of powers doesn't really matter. If the motive is Congress wants to decrease its own accountability, or whether the executive agency is trying to take over, it has the same effect. And voters have to understand who exactly is making these decisions so that they can have there's some accountability. That's critical in our system.
So we need to go to a quick break, but before we go, I want to ask you this. Is the solution primarily that voters, constituents need to hold their elected officials accountable, and essentially we as voters need to expect, hey, Congressperson so-and-so, I don't want you to write vague laws that sort of defer a lot of decision-making or rulemaking authority or powers to federal agencies. Let's rein in the federal agencies a little bit. Is that something that just needs to become sort of part of the norm of what voters expect?
It is. And then the court's role would be really as a backstop when the agencies try, even though Congress has been clear, or when Congress has made a mistake, or because sometimes they do, maybe even intending to make a clear rule, they don't. But ultimately, that's right. The Congress needs to leave less loopholes that can potentially be filled in.
Well, we're going to take a quick break, but when we come back, we'll continue our discussion with Bill Duncan, Constitutional Law and Religious Freedom Fellow here at Sutherland. We're going to talk about Supreme Court cases they're taking up that are going to impact free speech, property, and some other fun things. So stick around. This is Defending Ideas. We'll be right back.
Sutherland Institute is an independent, nonprofit public policy think tank based in Salt Lake City, Utah. Our mission is to defend the principles of the American founding and strengthen the institutions of civil society essential for those principles to endure. Sutherland provides research, events, and multimedia to policymakers and the public to promote the principles of faith, family, freedom, opportunity, and responsibility. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. Before we continue our conversation with Bill Duncan about the U.S. Supreme Court and the cases they're planning to take up for this new term, I want to remind you, if you like what you're hearing today, please visit us at defendingideas.org. you can subscribe to this podcast on Apple Podcasts, Google, Spotify, YouTube, essentially any of the major platforms wherever you like to get your shows. You can also find short clips from this episode and previous discussions that you can use and share on social media and use in your conversations with friends and family. That's defendingideas.org. So, Bill, let's walk through some of the other cases that are currently on the docket for the Supreme Court. There's one involving free speech concerns and what the government can or can't regulate with respect to speech, and then also get into some property questions. So first, let's go through some of these speech cases that you wrote about in your Insights article, which, as a reminder for listeners, we'll include a link to in the show notes so you can go through and read it as well. But free speech, it's a bedrock principle. What is the court going to consider with respect to that issue?
Well, there are two key cases. One is pretty interesting and unique one. Let me do the other one first because maybe it's a little bit simpler. This involves another previous court decision that involved abortion protesters, people who wanted to approach women who are considering abortion. They wanted to suggest they not do that. And the court upheld in that case a restriction that said they have to stay at least, I believe it was 8 feet away from the from the women as they went in, creating kind of like a buffer zone. Well, that you can see that that's potentially a problem. I mean, in this particular case, I'm sure that what the legislature was thinking about is, that this is a vulnerable time for people. But if you sort of carry that to other areas, I mean, everybody's sort of vulnerable in a free speech case. Politicians don't like to be approached by constituents who are unhappy with the decisions. Either way, free speech can be a challenging thing. And although we obviously want people to be very appropriate in the way that they express their opinions, we have to allow some freedom for people to express. And so in this case, the court is being asked to revisit that decision and to perhaps step back and allow people to, as long as they're willing to obey other laws. So there are other protections for people who, if someone is threatening in their speech or confrontational or the idea of assault is you're going right up against someone and making them uncomfortable. Those kinds of things would still be illegal. But if a person is acting appropriately, they're not doing anything that's threatening, free speech should allow for that kind of thing to happen, even if sometimes it makes us a little uncomfortable. So that's the issue in that case. And hopefully the Supreme Court will revisit its prior decision.
Can I ask you real quick on that? Because I think it is a balance question. You alluded to it of, well, there's a difference between speech or conversing with somebody and harassment and those kinds of things. Right. How do you strike that balance in the law? Because I can imagine in that circumstance, in this specific case that you wrote about, the Catholic mother wanting to approach somebody outside an abortion clinic and say, you're sure, that maybe there's some other options you haven't thought of. Essentially, where is the line, or where should the line be if it's unclear between, again, sort of just conversing? If I see you walking down the street and I say, hey, I want to go talk to that guy about his tie, and say, maybe you should wear a red tie instead. I mean, that's a very innocuous, silly example, but that alone is not illegal for me to do that. But then if you say, hey, leave me alone, and I persist, so I guess where's the line?
Yeah. Well, each state will have rules. There's federal laws as well. This is kind of an interesting time to be talking about this because people maybe have been watching the news in the last little while. I've seen some pretty troubling things where protesters are actually being aggressive and banging on doors and that kind of thing, and kind of some anti-Semitic things we've seen lately that are beyond the pale. Those things are forbidden by federal law and by state laws. You can't try and make someone feel fear. That's an assault. You can't attack someone. Like you said, if someone says, I made up my mind, leave me alone, then they have to respect that. You can't continue to do that. But we have to allow that most people who are expressing their opinions, whether we like those opinions or not, have the right to share those as long as they do it peaceably. Typically, you probably have heard a phrase that the court sometimes uses: time, place, and manner. There are some specific circumstances where, if you're trying to approach someone in the middle of a freeway, of course, that's not going to be appropriate. Or you're trying to approach someone in their own home. There are some settings, but we have laws already that deal with that question. Here we have an additional requirement that in this specific kind of protest, the state says, oh, you can't do that. Well, it appears that they're making kind of an exception because the state favors abortion rights. And so that's part of the concern here.
So there's another case related to free speech, and this is dealing with the NRA and sort of financial institution regulations. Walk us through that one.
This is a very interesting case. So the background, and again, I'm kind of describing this as the court would. They would look at from the perspective of the person who's challenging the law and the way they say it. They see the dispute. But the NRA says that New York's, some of New York's regulators that regulate financial institutions have communicated to these institutions that if they do business with the NRA, provide insurance or provide bank accounts or something like that, that they could be, these private businesses could be the subject of unfavorable regulations. This goes back to our first discussion too, and so let's assume that the bank is being audited or something. The implication is that the agencies are going to look a little more carefully at things and maybe be a little more aggressive than they would be. And the thinking is because you're doing business with a company that the state disfavors, because the state officials would like to see greater restrictions on gun ownership and gun use. And of course that's certainly those politicians have the right to have that opinion. But there's a concern reasonably that could be an abuse of power, because these agencies have the ability to make life harder on the businesses. Now, if the businesses are breaking the law in some way, certainly that's fine. But the specific threats, and these have come from messages that were shared, and there's a record behind this that this is really what's happening. That seems to go a little further, and so the agency is trying to limit. The argument is the agency is trying to limit the NRA's free speech, not directly by trying to put them in jail for sharing their opinions, but by making it almost impossible for them to do business in the state by threatening their the people that we need to do business just in a normal way.
Is it almost kind of a freedom of association question? Is that kind of bundled into the First Amendment, free speech, free association kind of ideas?
Yes, that is. In this case, freedom of association is a little bit less. I mean, because these are just businesses that are for profit. They're trying to, they're just doing business with anybody who will come to them. And of course, they can choose not to do business with NRA if they don't want to. The concern is that the government is sort of using them as a proxy to kind of wage their dispute with the NRA, and that's when that state power is at work, then we run into constitutional questions. If a bank says, "Hey, look, we're not going to do business with anybody who supports, assault weapons," they're free to do that.
So there is that important distinction that a private organization can choose who it wants to do business with in this context, but the government cannot come and force a private financial institution, or coerce them rather, incentivize or disincentivize to not do business with an organization just because it doesn't like the message or the stance of the organization. And I want to see if there's a way to distill down to a principle that our listeners can use if they find themselves in a conversation about this, because the NRA is an organization that can generate lots of controversy and robust public debate. And of course, the issue of gun control, it does that as well. And so I guess what's a good rebuttal to people say, well, if there are folks who believe that the NRA in this case is just a bad organization because it has a political view on firearms that they find untenable, could a rebuttal to that be, well, look, it's fine to have that opinion, but using government regulation to essentially harm an otherwise lawful activity is wrong? And maybe could the way to convince people of that be, imagine an opposing party or somebody you don't like in office using that same power against an organization that you do like? Is it kind of let's just turn the tables, and if you don't like it, then there's your principle? Yeah,
absolutely. And that's always been the way we've tried to understand and express our support for free speech is, in this case, maybe that speech is really, really something we don't agree with or we may find repugnant. But as long as it doesn't violate some other law, we have to allow some room because we may be the next one. In a state like New York, the issue is gun control, but you could easily see another state where it could be the exact opposite, that someone who is arguing for gun control loses their ability to do business, to bank or something because the government has that. One easy way to think of this is if we would be uncomfortable with the government directly limiting someone's speech, they should also not be able to do that indirectly. And I think that's maybe a good way of thinking about it.
Well, we need to take a quick break again soon, but as we go into that break, I want to ask, for the cases we've talked about so far, I guess, what are some things that you hope or predict will come out of some of these Supreme Court discussions that can sort of remind each of us and our listeners, and just all of us as voters, of the importance of the court's role, of the separation of powers, and just help us kind of, I guess, have that framework so when we hear these news reports come out when these cases are decided, we have a better lens through which to look at these issues?
That's a great question, because sometimes you'll hear criticism of the court, and the criticism is based, in my opinion, on they don't like the result. But that's not the way of understanding what the court does. The court is supposed to be the defender of our written Constitution and the laws that are made pursuant to the Constitution. And so we ought to be looking at how faithful is the court to that mission. Even if someone that we don't like benefits from a court decision, if that court decision is consistent with the Constitution, with the laws that Congress has passed, with other valid exercise of government power, then we say, well, I'm going to vote a way that I hope gets a different result in the future. But the court did what it's supposed to do, not to get the results that I want, but to faithfully apply the Constitution to specific facts.
Well, when we come back, I want to dive into that a little bit more, because you wrote another piece a couple months ago in the National Review about some of these criticisms of the Supreme Court and how they're kind of on flawed footing, to put it simply. So we'll do that. We'll kind of round out our Supreme Court new term preview with Bill Duncan. So this is Defending Ideas. Stick around. We'll be right back.
For a deeper dive into the issues you care about, read Sutherland Institute's official blog, Insights and Takeaways. You'll gain deep insights from policy experts and relevant takeaways voters need to know. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. I'm your host, Nick Dunn, and we've been chatting with Bill Duncan, who's the Constitutional Law and Religious Freedom Fellow here at Sutherland Institute, giving you essentially a sneak peek or a preview of what the U.S. Supreme Court is going to be doing in its new term that just started in October. We're going to continue the discussion and really center on what the proper role of the Supreme Court is and equip you with a better way to debate these decisions in these cases when they inevitably come up in the news, so you can argue from the standpoint of firm principle grounded in the Constitution. Before we do that, though, I want to remind you, if you like what you're hearing today, please visit defendingideas.org. You can subscribe to this podcast on Spotify, Apple, Amazon, any of the major platforms, wherever you get your podcasts. Just go to your platform and search Defending Ideas, and then make sure you click subscribe. You can also find short clips that we encourage you to share far and wide on your own social channels, and to help you in your conversations with friends and family about the ideas we're discussing today. That's defendingideas.org. Bill, to finish off this conversation, I think it's helpful to go back to essentially a reminder of the civic purpose of the U.S. Supreme Court. And I want to reference a different article you wrote back in September for the National Review. And the title of this is The Flawed Civic Understanding Behind Attacks on the Supreme Court. We'll include this link in the show notes as well. But in this article, you essentially argue that a lot of the controversy and public debate over ethics issues or other criticisms of the Supreme Court seems to be motivated more by just fundamental disagreements with the decisions rather than sort of a principled stand on ethics. And so I wanted to kind of ask you to help remind our listeners of the appropriate role of the court. And to tee that off, maybe I want to read an excerpt from your National Review piece about the court, where as you're talking in your piece, you mentioned that there are various surveys that are asked of Americans to kind of gauge how they feel about the Supreme Court. And one of the surveys that is kind of used as evidence that, well, the public is losing its trust in the court. This survey asks, and I'll quote now from your article, it asks how much the respondents trust the Supreme Court to operate in the best interests of the American people. That formulation suggests a representative role for the justices akin to that of an elected member of Congress, a role at odds with the court's ultimate responsibility to ensure equal justice under law and faithfully interpret and safeguard the Constitution and laws passed by the people or their representatives. So the question is this: people who are critical of the court, are they just flat out wrong on constitutional grounds?
Well, if the reason for criticizing the court is that they don't like the court's decisions, the answer is yes. That's right. Putting aside all the questions of who should be disclosing what, and I think that can be handled by the court. I think they've always done fine with that before. The real question here is, what is the court's role? Now, I think that the court does act in the public interest when they defend the Constitution, when they hold us to those documents. But the nature of a written Constitution is that it can constrain us from doing things we may very much want to do in any given moment. There are people, unfortunately, through time who wanted to persecute religious groups that they didn't agree with, or racial minorities who wanted to take advantage of them and deny them their rights. And ideally, the Constitution stands above that kind of temporary feeling and calls us to live up to a better aspiration. And so if the Supreme Court goes along with what kind of our we hope temporary aberrations in our opinions, public opinion, that court is not doing what it should be doing. The court needs to be really careful to do only what it's either specifically required to do by constitutional provisions or by other laws, or to apply those as faithfully as it can. Of course, there are disputes here and there about whether the court's doing the right thing. But when the court does something that's not supported by constitutional text or by some other legal provision, it's clear that they're outside the realm of what they've been asked to do. Now, we may like what they do in those circumstances, but we're wrong to like that in a way.
Is it kind of like the same Constitution that constrains me from doing something that I may like from a policy lens would also constrain, again, someone who I oppose vigorously on the other side from doing something that I would hate? So is it kind of reorienting the conversation back to, let's not view constitutional constraints as constraints that they limit us from doing the things we think are good policy. But really, they're creating a framework to where neither side can just run roughshod and implement something they really like, because that risks too much trampling on the rights of others in this country. Is that a fair characterization?
Yeah, that's a great characterization. And you and I have talked about this before. The famous play "Man for All Seasons," where the character Thomas More says, would you do away with all the laws in order to, I'm paraphrasing, but go after something that's clearly wrong? And one character says, sure, of course, to go after something that's clearly wrong. Yeah, it's worth throwing away all constraints. And Thomas More's response is, but then what happens when you're on the other side of that, when someone considers you to be the one that's in the wrong? You have no protections. And we want those protections to apply equally to each group, each opinion. And all of the cases we've talked about so far are actually good examples of precisely this concern. So this idea of the court's role is always critical. It's always important. And the court, in a lot of ways, has to be although there are some constraints on what it can do, ideally it respects its own role, doesn't try and go outside of that. That's what really protects our system.
I think a good example of that from this last term, the last big debate, and you came on a few months ago to talk about the student loan case and the court ruling on that. And that to me seems like a good example that, again, I want to frame it for our listeners as, how can we help the folks listening be equipped to persuade someone who might view the court, again, in this sort of constitutionally incorrect way? Because pretend for a minute that I'm somebody who likes the idea of student loan forgiveness. I don't. I think it has a number of flaws. But sure, just for the sake of the point, if I say, well, I really think it's a good policy idea to have student loans forgiven, it's going to have all these economic benefits and all these various things. For someone who might have that position and say, I don't really care if that's enacted by the president just taking an action, or Congress or someone else, as long as I get the policy outcome I like, then the policy outcome is what matters. That's the good thing, so whatever gets me there is fine. Why is that a wrong-headed and potentially even dangerous position?
Well, there's two reasons. One is that if we value the Constitution and its principle of separation of powers, That's completely antithetical to that. The Constitution says there are certain people who should be making certain decisions and not making other ones. Now, the secondary question is, well, why does it say that? Why do we even care? I mean, you're right. If we may very well like a decision that the president's going to make or whatever, why should it matter who makes it? Well, part of the answer is that the framers of the Constitution were concerned that if only one branch of government is able to make all of the important decisions, and then we are at risk because, that seems great when the decisions go our way, but if they then they take on power to do things that we don't like or that are clearly wrong, and that does happen. It doesn't take a lot of looking at our history to see times when a president has said, I feel a threat from someone like Japanese Americans, and so they go to internment camp. If there's no check on that kind of behavior, then all of us are at risk at some point, whether it's right now when we want our student loans forgiven or in the future when we're the lender and we don't want to have those loans just disappear and, with all the effects on the economy.
And I think there's another important distinction because often people in these arguments, they say, well, the policy that I'm advocating for that I may not care how it gets done is one that's good and popular among Americans. Right. But aren't there examples, and you mentioned one already, aren't there examples in years past where just because something might have majority support among the populace, it could still be a horribly wrong thing to do that tramples on the rights of the minority?
Right, absolutely. And maybe a simple example, because we often talk about religious freedom, is there was a lot of animus towards Catholics, and as they were coming often immigrant populations were Catholic, and they were not well understood by others in the country, and so their rights were limited in various ways. I think anybody in 2023 would look back and say, "Oh gosh, that's so embarrassing. Why do we ever do that?" And there are many examples, slavery and other things. We want in some ways to have a check, even on our popular opinions. The Constitution is very clear that when there is a branch that's supposed to represent the kind of the popular feeling of the people, that's the legislative branch. There are constraints on what they're allowed to do, what they're not allowed to do. Some of those are enshrined in the Constitution and our fundamental freedoms. And so our system will work. It allows Congress to make some bad mistakes and to perhaps come back. But there's some mistakes we don't want to allow Congress to make. We don't want them to trample on the rights of others. We don't want them to take away free speech. We don't want them to limit our religious freedom or to put a person in jail for something that that's not fair. Those kinds of constraints are what's needed. If the court steps back from enforcing those constraints because it's concerned that the American people don't support them at any given moment, then again, the protections are gone. And in the future, when we become the target of Congress's overreaching or the president's overreaching or even the court's overreaching, there's no constraints left.
So we're almost out of time. So I want to ask you as we close, for our listeners, in the coming months, and I should have clarified it before, the Supreme Court, they can issue decisions anytime in their term. Is that right?
Sure, right.
So there could be things coming out anytime between now and next June. They might drop a lot in June, especially if there are controversial cases as we saw this last year. But essentially between now and June 2024, as we are watching for news to come out about court decisions, what is the most important thing that our listeners should remember as they're reading and listening and watching this news and hearing this discussion about Supreme Court decisions that can help them in their conversations with others who may not see the court in the same way? What's the biggest thing we need to keep in mind?
But I may say it this way. It's very appropriate to criticize court decisions. I've certainly done that, and I think everyone does. That is a very appropriate thing for us to do. In a free society, we should have that right. Having said that, if we criticize them on the basis of what the court is supposed to be doing, then we're in a good spot. We can say, well, I think the court read that statute wrong. I think the court should apply the Constitution in a different way. And I think this is what it meant, or that kind of thing. That's a good conversation to have. When we instead say, you know what, I hate the kinds of things the court's doing. They're going against my policy preferences. We ought to push those guys out and find better justices or things like that, or pack the court, or whatever the specific strategy is at a given time. That's when we veered into a place that's I think unsafe from a civic perspective, because we're asking the court to do something it's not supposed to do and expecting results from it that will actually harm us over the long term.
So that is some very good civic 101 education, a reminder for all of us. So Bill, thank you again so much. Bill Duncan, our Constitutional Law and Religious Freedom Fellow here at Sutherland. Thanks for lending your time and expertise. Always a pleasure having you on the show.
Thanks. Great to be with you.
But we have one more quick break before we leave you with some talking points to prepare you for the discussions we hope you'll be having about the Supreme Court over the next year or so. This is Defending Ideas. We'll be right back.
Sometimes it's hard to keep up with the latest policy debate that affects your life. The solution? Subscribe to Sutherland Institute's weekly newsletter, where you'll find in-depth insights from seasoned policy experts, compelling multimedia, and advance notice of special events. Visit sutherlandinstitute.org.
Welcome back to Defending Ideas. Before we go, I want to reiterate one thing from our conversation with Bill Duncan, and we're grateful again to him for lending his expertise, giving us a preview of what the court is going to be discussing in this new term, and also reminding us of the proper role of the court. And to that end, I want to leave you with this. If you find yourself in a debate with somebody about maybe a given Supreme Court case that might hit the news in the coming months or any time between now and next June, this is the lens that I think will help better lead to having a good conversation, a productive conversation about the role of the court. And that's this, to remind folks that the correct role of the United States Supreme Court is not to create policies that you or I might like, nor is it to reflect the popular will of the American people. We have other branches at the federal level for that. The proper role of the Supreme Court is to uphold the Constitution and the law, protecting the separation of powers and the constitutional system of checks and balances that we have in this country. Now, that might feel like a constraint at times for something you may want to happen, but that also means that it's going to act as a constraint to other elected officials you may disagree with deeply, and you may wish to have their power curtailed by the Constitution. But it has to be evenly applied to be a true constitutional principle that can work in our system of governance. I think these framings and this way of approaching the issue will lead to better conversations if we can filter all of our debates about Supreme Court cases through this lens of the proper constitutional role of the court. It'll lead to better civic understanding and more elevated discussion about the impacts and merits of what the Supreme Court does when it starts its term and finishes its term each year. With that, we want to remind you, if you like what you heard today, please visit us at defendingideas.org. You can find clips from this episode that you can use on social media, as well as previous episodes. You can also subscribe to the podcast on Apple Podcasts, Google, Spotify, any of the major platforms. Just go to wherever you get your shows and search for Defending Ideas and hit that subscribe button to stay up to date. You can also watch this entire episode and previous episodes on YouTube. And if you want to support the work of Sutherland Institute, please visit sutherlandinstitute.org/donate. Thanks again so much for joining us here on Defending Ideas from the Sutherland Institute in Salt Lake City. I'm Mick Dunn. We'll see you next time.